struck down the decade-old state law prohibiting marriage between persons of the same sex. Judge Hanson declared that those laws violated the state constitutional guarantees of due process and equal protection. His decision is on appeal to the Iowa State Supreme Court, and its enforcement has been stayed pending the results of that appeal. Now, why I believe this deserves the attention of the nation is because we first have to hope that the Iowa Supreme Court shows more wisdom and common sense than its Massachusetts counterparts and reverses Judge Hanson's decision. I believe the citizens of Iowa believe that the authors of the Iowa Constitution never intended its provisions to authorize same-sex marriage, and we should hope that the Supreme Court, that all members of the Supreme Court of Iowa recognize that fact. There is no saying that a community or a people are best defined not by the problems they debate, but by the principles they take for granted, by the values that people hold sacred and above debate. The sanctity of marriage used to be one of those principles in America. It's a sign of our cultural decline that we now find ourselves in a national debate over the proposal to allow persons of the same sex to marry each other. Now, I do not believe personally that the government has any role to play or any right to decide who I should care about as an individual, and that's certainly not the issue here. By tradition and by our constitutional foundations, our nation is very tolerant of minority viewpoints and unorthodox lifestyles. Most states recognize and accept the fact that people of the same sex choose to live together. In many states, these arrangements are recognized in laws as civil unions and afford many of the legal benefits of marriage. Yet not in a single state has the state legislature or the people by referendum decided to call these unions a marriage. That leap has been taken only by unelected judges, not by the people of any state. Such judicial creativity is but the latest example of judicial activism, an attempt by activist judges to legislate where the Constitution is silent, where it says something they disagree with. Roe versus Wade was a notorious example of the judicial usurpation of democratic decision-making in an expansion of abortion rights, and now we are witnessing that usurpation in the realm of the marriage laws. The Congress of the United States enacted the Defense of Marriage Law, or as it's referred to, DOMA, to limit the effects of state courts to try to establish same-sex marriage. The act says that people of Iowa do not have to recognize a same-sex marriage performed under the laws of Massachusetts or any other state. Yet DOMA does not protect the people of Iowa from some foolish or arrogant actions by Iowa courts. For that reason, I support the federal constitutional amendment defining marriage as a union between one man and one woman and prohibiting any state from recognizing same-sex unions as marriage. We do need a constitutional amendment, and this is a perfect example. What is happening here is a perfect example of why we need a constitutional amendment. Some people would ask if this is worth fighting for. Is it a distraction from other important issues that we confront as a nation, such as the war against radical Islam, the reform of our schools, immigration, law enforcement, improvement of health care? I believe these arguments against, any argument against taking up this issue is mistaken. I believe that this is one of the most important questions facing our nation, and it cannot be postponed. We must first recognize that it is a question forced onto the public stage by the advocates for homosexual marriage. We cannot wish it away or hide from it. We cannot avoid dealing with it because the advocates for same-sex marriage won't let the issue go away. Activist judges keep attempting to rewrite state constitutions to authorize same-sex marriages. Activist groups keep demanding that politicians take a stand, and they try to punish anyone who does not agree with them. Thus, the activism by Christians and others opposed to same-sex marriage is in truth a defense against this cultural war that has been declared by radical activists intent on imposing same-sex marriage on American society. It's not Christians or conservatives or traditionalists who have created this fight, but we should not walk away from it either. Neither should the Republican Party walk away from it. To pretend that we can be neutral or non-combatants in this battle is either fatally naive or deliberately deceptive. To abandon the battlefield through indifference is to hand victory to the proponents of same-sex marriage. I ask again, why is this issue so important?
so people can protect their loved ones.
It is important first as a legal principle. We must defeat the judicial activism that is trying to institute a radical change of our laws by fiat. It's simply not true that laws restricting marriage to a union between a man and a woman are a violation of the due process or equal protection rights guaranteed by state or federal constitutions. States not only have a right to regulate the institution of marriage, they have a right and a positive duty to do so. I believe Judge Hanson is flat wrong to say the state of Iowa, through its legislature, has no legitimate interest in regulation of the institution of marriage. You might as well say the state has no legitimate interest in regulating the validity of commercial contracts, or prohibiting prostitution, or public executions. The argument used most often to justify same-sex marriage, that any union between consenting adults ought to be lawful, would also justify polygamy. If a community cannot limit marriage to a man and a woman, how can it stop two men and a woman, or three women and two men from declaring a communal marriage? The child is just as well off with two mommies instead of a mother and a father. Why is it not even better off with four mommies or three daddies? The people of Iowa did not choose to put this issue on the ballot. They did not choose to force the state legislature to defend its constitutional prerogative to define marriage. The issue was forced onto the stage by an activist judge responding to pressure from radical activists intent on overturning well-established law and customs. But now the issue is on the public stage. We must defend our laws and our culture from this attack. Whether or not it eventually requires a federal constitutional amendment, whether we'll get it, I don't know. As I say, I hope so. But I do know that the people of Iowa should not surrender their constitution without a fight. Thank you very much.
Do you think that Judge Hanson or any judge that rules for same-sex marriage should be impeached?
Impeachment, that's an issue for the people of the state of Iowa to deal with. I know that Bill Salier, who is my campaign chairman, is involved with a petition drive for that purpose. If I were a citizen of the state of Iowa, I'd sign it, but that's his business and the state's business.
Earlier this week, Fred Thompson was in the state and talked about a different constitutional amendment, not a ban, but more saying that the judicial group does not have the right to rule on this, that it's up to state legislators. Do you think that goes far enough?
You could actually, what you could do is take DOMA, for instance, which is now just a statute, and if you were to pass it as a constitutional amendment, that would be better than what we have. It would be certainly, it would just essentially say it is truly up to states to individually determine. Right now, even though that's what the law says, that's what the federal law says, anybody, a judge or any judge, can rule it unconstitutional based on a violation of the 14th Amendment or anything else that they determine.
So my question is, would you be satisfied with that, letting states decide, or do you think it should be a federal ban?
I would prefer a federal ban. My second position, or a secondary position I guess I would take, would be to constitutionalize DOMA.
Can you clarify your stand on civil unions as opposed to gay marriage?
Well, again, civil unions, the only reference I made to it here is to point out the fact that in no case were they determined to be marriages, I mean, by normal standards, and that has happened in no state. That no group of people, no majority of people in any state, or certainly no majority of the people of the state of the United States, of this country, have made that decision. This has always been by some sort of judicial fiat, and that's what's disturbing here. That's really the issue that we're dealing with, or trying to deal with, is this judicial activism. Again, it wasn't brought to the attention of the general public as a result of some initiative passed by a state by the people of the state. It's always happened as a result of pressure groups bringing it forward. If we allow this to go, as I say, how can you possibly say if you know, the thing I'll tell you, the thing that actually got me to focus on this and decide to come out here and actually say something about it. So when I read this article, it starts out describing what happened, and it says that Judge Hanson decided, his reasoning was based on, but not limited to, the quote, absence of a rational relationship to the achievement of any legitimate governmental interest.